Welcome, and thank you for the opportunity to spend this time with you. I'm Kristina Acri. I'm professor of economics at Colorado College, and I am delighted to be the moderator for this first panel. I'll start by briefly introducing our panelists and then give them a few moments to reflect on our charge and their industries in particular. Terrence Hart serves as General Counsel for the Association of American Publishers, which he joined after serving as Assistant General Counsel for the U.S. Copyright Office. He is the founder and author of the highly regarded Copy Hype, which the American Bar Association recognized as one of the top 100 legal blogs in the U.S. John is the Director of Patent Licensing at Nokia. He is an intellectual property counsel and business advisor with 10 years of in-house global telecommunications, patent licensing, litigation, and policy experience at Nokia. Laurie is Vice President and Counsel of Government Affairs at Qualcomm Incorporated, specializing in U.S. patent policy matters at the federal and state levels. She also supports Qualcomm's government affairs initiatives to promote strong intellectual property rights in emerging markets. And Hans is Deputy General Counsel and Vice President for Intellectual Property for the Biotechnology Innovation Organization, a trade association representing over 1,000 biotechnology companies across industry sectors. His 20 years of experience span work on drug development programs, patent prosecution, and portfolio oversight, as well as sales and marketing legal compliance. I now welcome your opening remarks, and I'll start with you, Terry.
And is this on? All right. Well, thank you, Kristina. Thank you to SIP Squared for inviting me here today. As Kristina mentioned, I'm General Counsel at the Association of American Publishers, where we advocate on behalf of publishers in the U.S., including trade, educational, and professional and scholarly publishers. And I'd like to start this discussion of exclusive rights by making one observation about copyrighted works in general, but certainly the works that my members invest in and publish. And that's that no one knows the value of any given work. Certainly they don't know it before the work is published, but it's even difficult to understand the value of any given work during the duration of copyright protection. Now, this is a premise that is built into copyright law. And in fact, just as a side note, copyright recognizes this explicitly through several doctrines. So for example, since the 1790s, U.S. copyright law has provided for statutory damages. These are predetermined damages that copyright owners can pursue in lieu of actual damages. And in the 1960s, when the U.S. Copyright Office was studying the revision of the Copyright Act, it recommended that the new Copyright Act includes statutory damages, saying that the need for this special remedy arises from the acknowledged inadequacy of actual damages and profits in many cases. The value of a copyright is, by its nature, difficult to establish, and the loss caused by an infringement is equally hard to determine. Similarly, a second doctrine is termination of transfers. So the Copyright Act in the U.S. provides that any assignment or transfer of copyright comes with it an irrevocable right to terminate that transfer after 35 years. And if you look at the legislative history of that provision, Congress said that a provision of the sort is needed because of the unequal bargaining position of authors, resulting in part from the impossibility of determining a work's value until it has been exploited. So those are some specific examples, but really this premise permeates the overall framework of copyright, which is built on the structure of exclusive rights. These exclusive rights give copyright owners the sole ability to determine who, what, where, and how they provide access to their works. And the goal of the copyright owner is to maximize the value that they capture from those works. And exclusive rights, which are under the Copyright Act divisible, format neutral, technologically neutral, allow copyright owners to offer the same work in different formats at different price points and on different terms. Now, of course, there are external constraints on what they could offer. They're constrained by price and terms that the market will accept. This includes competitive pressures, it includes consumer perceptions of the value of the works and consumer expectations. But there's also internal constraints on what copyright owners can offer, because if you're looking at different versions of the same work, there is a degree of substitutability between the product offerings, such that the price and terms of one will also impact the demand for other offerings. So to use an example from the industry I represent, since the mid-20th century or so, the standard practice for trade publishers has been to release books in both a hardcover format and then also a lower cost paperback format. And the distinction in these two formats is not just in the perceived quality, right? Hardcover seems to have a higher value than paperback versions, but also in the timeliness of the two formats. The releases are windowed, with the hardcover appearing in the market several months before the paperback version appears in the market. So this strategy allows publishers to capture those consumers who are willing to pay a higher price for the same work, while also providing an offering for the consumers that are only willing to pay a lower price. But of course, that raises the question, what's the optimal window between when you release the paperback version? If the window's too short, then the publisher runs the risk that they'll cannibalize the higher value hardcover sales, because some of those high value consumers may be more willing to wait for the lower cost paperback if they know that they don't have to wait for long. But if the window's too long, then of course you run the risk that the demand for the work in any format has tapered off, and the low value consumers may have moved on to the next book or the next video game or the next movie or something else to spend their money on. Now, of course, things are a lot more complicated today with the advent of digital formats. That has made business decisions exponentially more complex. On the one hand, copyright owners do have far more flexibility of offerings and terms for digital formats. They could limit by time period, they could have rentals, they could offer bundles or subscription services, and really slice and dice the offerings in far more ways than they could with physical products. But on the other hand, there is a significantly greater risk of infringement, because with digital formats, you can make perfect replicas easily, instantaneously, and distribute those globally in the snap of fingers. But the underlying principles and logic that copyright is built on remain the same. And bottom line, the exercise of exclusive rights by a copyright owner are related to each other, and that relationship is dynamic. So that means that certain interventions into the copyright framework, and we'll talk about limitations or exceptions or remedies, those interventions should be scrutinized very carefully, since their impacts would reach beyond their intended targets. In other words, the fallacy that we have to be careful of is that you could just sort of pull on one thread and not affect what is happening with the exercise of exclusive rights on things beyond the target. So I just want to name some examples of specific interventions that I think invite this scrutiny. One is this idea of digital first sale. Attempts to force the exercise of rights in ways that are incompatible with the economic logic creates untenable risks because of the ease of copying and distributing digital files. A second example are compulsory licenses. They should be heavily disfavored and have historically been heavily disfavored in the copyright field. Not only do compulsory licenses raise the same concerns as any price controls, but they, again, have impact on other exclusive rights. They can affect the demand for or the value of product offerings beyond what is being licensed under a compulsory license. And thirdly, I'll mention license restrictions or contract preemption provisions. They should also be heavily disfavored. Again, not only is this type of intervention distorting the market, but the distortion has impacts on other offerings that are not the subject of these restrictions. So to go back to my original premise, no one can ever know the value of a given work. The majority of the value of any work distributed to the public is shared by the public. We all benefit when authors and creators put their work out there, and we could enjoy them, we could learn from them, we could be inspired by them. The exclusive rights of copyright, combined with the business judgment of authors and publishers, the risk of which they bear alone, allow copyright owners to capture that share of the value that's rightfully theirs and which enables them to invest in the next generation of works. So, thanks.
John?
Thanks. I think I'm going to use my opening remarks a little bit differently. I think I would use this briefly just to explain who Nokia is and what we do, so you have a better understanding of our issues and our interests relating to the topics we're going to discuss today. Let me just say that the views, I'll offer the disclaimer that the views that I express today are going to be mine alone and not necessarily those of my company. So let's just get that out of the way. Let me explain that Nokia was established in 1865 as a single paper mill in Finland. Over 160 years of existence, we've had multiple business transformations. We have gone at any time from producing paper to rubber boots to televisions to undersea cables, car tires, and eventually state-of-the-art wireless and wired communications equipment, which is our business now. Indeed, we were the world's largest seller of mobile phones from 1998 to 2012, and that's how a lot of people still know us and remember us. But we've always been not just a provider of cellular phones, but we were also providing the infrastructure that communication service providers needed to build their networks that would connect all those phones together. We, along with Ericsson and to a lesser degree Samsung, stand as one of the only worldwide providers of that infrastructure equipment now. The business model today that we use is to produce and sell that infrastructure equipment along with related software and services. Through development of the products and the related research necessary to constantly evolve and improve those products, we are constantly innovating. The innovations result in patents, many, many patents, and that's our primary reason for being on the panel today to discuss that. We have one of the 20 largest patent portfolios in the world. Currently, we hold more than 20,000 patent families, most with several family members that have been filed in various different jurisdictions around the world. Notably, around 4,000 of those patents are declared essential to one or more telecommunications or video standards. The most familiar of those to most people in the audience would be the Wi-Fi standard or 2G, 3G, 4G, 5G telecom standards. But we also have standards patents relating to video compression. H.264, commonly known as the AVC video codec, H.265, known as the HEVC video codec, and now VVC, which is the next generation that streamers and others will be using to provide compressed video to you wherever you are, whenever you want it. Being one of the top holders of standards essential patents, many patents in our portfolio are necessarily infringed by any companies that manufacture or sell products that utilize the communications and video standards. Those could be cellular smartphones, tablets, any sort of computer devices, connected automobiles, smart televisions, things that connect to the Internet of Things. These are all products that are utilizing the technologies that we've developed. So we have well-developed patent licensing programs in which we negotiate with the producers of the devices to try and reach licensing agreements in which they pay us royalties for the use of our patented technologies. That licensing revenue is then in turn plowed back into our research and development to help generate the next generations of the technology that people use to communicate. We have innovation centers in 17 different countries, and many of our roughly 85,000 employees are involved in research and development. We've reinvested 150 billion euros into research and development efforts over the last 20 years usually around 4 to 5 billion euros a year, which constitutes around 20%, 15 to 20% of our annual turnover. So just working backwards, you see that licensing revenue is vital to our viability as a company. Patents for our technology are vital for the licensing revenue. Exclusionary rights that we'll talk about today are vital for the importance of the patents. So the sort of transitive property that you see there, you can see that the importance of exclusionary rights for Nokia is really an existential concern for our business. Thanks.
Thank you. Hans, please.
Well, first of all, thanks to SIP2 for inviting us. So I work for the Biotechnology Innovation Organization. As you heard, we are a trade association. And as such, one of the many things that really interest us and that are important to our members' business are, in fact, exclusive rights, or IP rights, as I'll refer to them. I just want to say, real quick, what we really like about SIP2 and the reason why we keep being involved is its ability to convene like such a diversity of interests in intellectual property and both different commercial interests as well as different academic interests. I think SIP2 is quite unique. And if you haven't been associated with it, check them out. Right? I think it's a really unique and unusual group that you will not find elsewhere in the country. And we're proud to be associated with it at Bio. So with that, Bio, as I said, is a trade association for biotechnology. We are the world's largest biotechnology trade association, not because we're so incredibly awesome, but because we're a mainly US-based organization, and the biotech field, both as a scientific field and as an industry, even to this day, I think is quite unrivaled internationally in the United States compared to the biotech sectors of other countries. This is not lost on the governments and policymakers of countries with which we either collaborate or compete, or both. We receive many inquiries from associated organizations, colleagues around the world, asking about why the US biotech model has, at least historically, been so unusually successful, right? What measures should be taken to emulate it in other countries? We take this as validation that over the last 40 years or more, since about the 1980s when this industry was born in the United States, we must have been doing something right that has worked quite well. US research productivity in the biomedical sector is very high. It's the highest in the world. More than 65% or so of all new treatments, new therapies that get invented and developed originate in the United States at US research institutions, US businesses, and US national centers and the like. So that's more than the rest of the world combined when we talk about new therapeutic technologies and treatments in the biomedical space. This is very important. It also inures to the benefit of US consumers and patients because new treatments that are invented and first brought to market very often become available in the United States first, often years before they become available in other, even relatively wealthy and industrialized countries. So there are many benefits that arise from the biotech business model as uniquely conceptualized in America that make it both special and that bring benefits to the country. And it's something that I think the country should be proud of. I myself wasn't born here. I came here after getting my education for a postdoctoral fellowship and to advance my career. And I can tell you from personal experience, there's no place like it, like the United States, that provides as many opportunities for scientists and those who want to fund science. This is not a foregone conclusion that it will forever be this way. And the discussion we're having today about the scope of exclusive rights, even just for the United States, has implications not just for our own commerce or for the country's international leadership in innovation and technology development. It also has implications for, the health of the country and for patients and consumers on a very personal level. The biotech business model is going to inform my further discussion of the role of exclusive rights and how I will respond to Kristina's questions in another discussion. So it's, I think, relevant for those of you who may not have thought about this recently, about, okay, what is the biotech business model? What is that anyway, biotech? All right? Biotech is, as an industry largely of small development stage companies who are the biggest part of the ecosystem. BIOS members also include big and established corporations whose names you would recognize. International corporations that make drugs, pharmaceuticals, medical devices, even consumer products. But the bread and butter of our membership, which I think I might have said this, how collectively the small companies that hold 70% or more of the development pipeline, the bread and butter of our membership are the small development stage companies that are, all of them, still years from bringing a product to the market. Right? They are, for the most part, in product development at the conceptualization stage and the proof of concept stage. So do not think of our companies mainly as businesses who sell stuff to consumers. Think of our members as mainly businesses who are in the market of developing products and trading technology to advance them towards the marketplace. Now, what are these products? Well, what's the deal with this business model that I tell you about and that I say is so unusual, perhaps? Well, biotech products, first think about how long it takes to bring a typical biotech product to market. This is true both for new medicines, biopharmaceutical drugs, and new agricultural biotech products like a new drought or insect-resistant seed product that may be especially adapted to both regional growing regions in the United States or in the developing world elsewhere. But bringing these products to market from conceptualization to market approval, if it ever occurs, on average takes about 10 to 15 years. For agricultural products, a new seed actually takes even longer than a drug. Drugs take approximately 10 years, a new seed product takes more than 15 years. This means when we talk about exclusive rights, it is very common for a new drug, for example, to be approved by the FDA and to go to market, and more than half of its patent protection, at least the initial patent protection on the compound that was invented, has already expired by the time the product even goes to market, right? So if you're looking to rely only on that first patent, the main patent, when you invented the magic molecule, right, that patent is more than half gone before you even make your first dollar in sales. Right? And it really shortens the lifetime in the market from which you can expect to profit from at least that patent. We can talk more about the bag of intellectual property that is also involved, but this is a very important thing to remember. It takes a really long time to get to market, and the chances of getting there are really low too. Right? Success rates in biopharmaceuticals from the time you enter clinical trials to FDA approval, if it ever occurs, those success rates are only in the 10 to 15% range, right? So we have a business model where 8 to 9 out of 10 companies will probably fail to bring a product to market. And yet, they keep being founded, they keep popping up like the proverbial whacking the mole, right? Some get acquired, some wind up business operations after their compounds don't work. Others basically reinvent themselves and start working on something else. In our board of directors at Bio, we have CEO scientists, serial entrepreneurs, some of whom have founded like 8 or 9 companies over the course of their career, have never brought a drug to market, and yet 2 years later they show up again with yet another company. And the amazing thing is they find people who are willing to have the confidence in them, who are willing to invest the close to $2 billion in fully capitalized costs of bringing a drug to market, right? And who are willing to spur them on in this almost hopeless effort of bringing yet another smart idea to market, and it's probably going to fail. But as a business model, it's a very strange thing. But you as investors, at least those who are willing to specialize in the field, keep coming up with ways to fund these kinds of operations. What do investors look for? And I've worked in small companies like that. Right? I've worked on several drug development programs, and believe me, none of them ever came to fruition. I'm in good company. But investors keep coming in, and they ask, what do you have? We describe our technology, and one of the things they will always ask, not just, do you think you have freedom to operate? Right? That becomes a question, especially when the company becomes more mature, when you go in for a third or fourth round of funding if you need it. Freedom to operate, of course, is important, but what they ask first, even before they ask that, is, do you have intellectual property rights? Have you secured patent rights on this? And that really matters to them for funding. So our companies, you might think, what, patents, I'm going to focus a bit on patents. You might think patents will often be used to sue other people, right, and to fight big commercial battles against your competitors. Nothing could be further from the truth. But most of our companies use intellectual property in entirely different ways. They use intellectual property to partner, to attract capital, as I described earlier, right, to pass drugs or biotech products up the chain of development between corporations that are better suited to do the next step of development. It's very common for biotech products to have changed hands 2 or 3 times. By the time they reach the marketplace, they will have been under the control of 2, 3 or more entities. Right? Sometimes it even starts at a publicly funded university, which then licenses out an asset to a company that licenses it to a bigger company, which licenses it to another company that finally brings it to market. So for the orderly dissemination of technology and for the partnering and collaborative framework that is so very important in biotechnology, intellectual property rights and patent rights are a critically important ingredient because they are, if you will, the grease that allows businesses and funders to collaborate and to enable a system of innovation that, again, as I started, other countries very much want to emulate. I will say only these additional things about the business model, and then we can go on. So once in the marketplace, a biopharmaceutical product, just like agricultural biotech products, once in the marketplace, these products are also very long-lived. They don't only take a long time to come to market. When they're in the market, they stay in the market for a really long time, very often. We have examples of drugs that were introduced 40 or 50 years ago, which are still perfectly good drugs that are still widely used today. Right? In other industries, there's a quicker turnover of innovation and disruptive innovations. We don't have it quite that much in biotech. Our innovation cycle, unfortunately, continues to be relatively slow, right, and requires long time horizons. Our products are also relatively easy to copy. Think of a biotech seed, right? A patented biotech seed that's insect resistant or specially adapted for a certain growing region in the United States. Nothing could be easier than replicating that patented seed. You don't even need a factory or an engineer to make more of the patented invention, whether you have permission or not. In other areas, like biopharmaceuticals, those may not be as able to easy to replicate, but we have laws in place that systematically are meant to reduce the barriers to access and that to enable the market entry of copyists, if you will, at the right time, if you will, right? So copying or the provision of very close substitutes of products in the biopharmaceutical and bioagricultural space is also very common. It's not hard to go into competition with a rights holder who developed a path-breaking invention if you're in the biotech space. It requires a tiny fraction of the original investment that the innovator had for you to also go into business and sell, identical or very close substitutes. And that, combined with both the commercial attractiveness and I think a lot of policy debates about the social utility of these products, is driving a lot of pressure both on our business model and on the intellectual property rights system in ways that we can probably explore further. But I hope maybe with this foundation I gave you like an insight into why would biotech companies think about IP in these particular ways, right? And I hope to explore those further. So thank you again for having me. Thanks for coming today.
And Laurie, please.
Sure. Hopefully this is on. Thank you very much, and again, thanks to SIP Squared for having us. Let me also give you a little bit more insight into who we are as a company and to sort of tie together some of the threads that you've heard from the previous speakers. Qualcomm is the world's leading developer of wireless communications technologies at a foundational R&D level. And we are also the world's leading designer of advanced semiconductors that go into mobile devices and a variety of other industry sectors, including auto and IoT and so forth. We were founded in 1985. We were, at the time, the kind of quintessential startup company that we think about in terms of what the patent system is meant to enable. We were, at the time, a group of leading scientists in what was then a nascent field of wireless communications. This was sort of the era of the huge brick phone that you might remember if you've seen Wall Street or one of those movies from the 80s. And we had invented what we thought was a truly disruptive means of wireless communications that could become a platform for a transformative effect in what we think about in terms of mobile communications. And that has remained largely our role over the next 40 years. We are the R&D arm, along with companies like Nokia, of the mobile ecosystem. And if you think about what that means in terms of impact and R&D investment, if you think back to the 90s, the early 2000s, the era of the feature phone where, a device in your pocket became your predominant means of voice communications, that ongoing investment in R&D led to another inflection point in the 2000s where this device in your pocket became the most powerful computing device that had ever been invented. Supplanting the role of your laptop or any other computer in terms of its capability to become a platform not just for all means of communications, but for entirely new business models. We're now at an inflection point with the convergence of advanced communications, advanced computing power, and generative AI to experience a new inflection point in terms of what this device will enable. And again, those evolutionary and kind of revolutionary leaps in communications are all enabled by massive investments in R&D that we as a company completely self-fund through our patent portfolio, through our licensing business. And so for each generation of cellular technology, what we refer to as the Gs, you've probably heard of, we're in the midst of a 5G era, what will eventually be a 6G era. There's about 10 years of advanced R&D that we self-fund as a company. There's about 10 years of a standardization process that John alluded to that is a continuous investment in the R&D that forms the standard, and that standardization process is kind of like a global innovation contest. The best inventors in the world, and again, there are not a lot of them that are making these huge investments in advanced communications technologies, but we come together as a ecosystem and we agree upon, what are the best of class technologies that should form the new blueprint in advanced communications. And that ongoing R&D cycle is both a marathon and a sprint, and it's only possible if you have a strong, stable patent system. And so when we talk about the role of exclusive rights, that is a linchpin of what we think about as an intellectual property system that is inherently a property system. And just to build on, some of the comments that have been made, I think one of the kind of paradoxical aspects of this notion of exclusive rights, which of course I think are often mischaracterized as a means of kind of holding close your technology position in a critical space, it's actually the opposite. The fact that we have exclusive rights as the foundation of our intellectual property system, as our patent system, our copyright system, that's what not only incentivizes these R&D investments in the first place, it's what allows us to share these technologies broadly. And again, if you think about a technology space like advanced communications, where today you can talk with anybody in the world without even thinking about it. I mean, again, for those of us who are old enough to remember what it was like to have that phone that was connected to your wall where, those types of technological advances that are so transformative in our lives that we now take them for granted, those are not possible if we don't have a system of property rights that allows us to share those technologies broadly and to collaborate, as Hans was saying. And again, that is really the fundamental role of our system of patent rights, to encourage companies and industries like those represented at this table to make these huge R&D investments in order to build technological ecosystems that become the foundation for new business models, new innovation, new economic opportunity. And increasingly, the conversation in Washington, for those of you who are following it, increasingly understanding the critical role or the critical nexus between technological leadership and national security. So for us as a company, the role of patents historically has been to allow us to be that R&D arm of the mobile ecosystem for almost 40 years now, to share those technologies broadly throughout the world, to use the revenues we earn from our patent licensing agreements to maintain that investment equation. I think it's worth noting that increasingly we are competing with companies across the world that benefit from a kind of top-down subsidization model, unlike the bottom-up R&D investment model that we experience in the United States. And as we think about, how do we maintain technological leadership vis-a-vis companies that are benefiting from government subsidization of one form or another, what does that mean in terms of our ability to maintain that competitive edge, to maintain that ability to run faster through the strength of our innovation? And again, I think it really puts in sort of sharp focus the importance of our intellectual property system. It's worth noting that in the United States, the vast majority of R&D that supports critical investments in what we consider to be the most important technologies today, those are largely self-funded within the private sector. We don't take any government funding to support our R&D investments, which are, like Nokia, is about 20% of our revenue every year, about $90 billion in aggregate over the life of the company. That's true of most technology spaces in this country. We rely heavily on the private sector to fund that innovation platform because we believe that the market is the best means of fostering that innovative activity. But that system starts to break down if we no longer have a reliable intellectual property system, a reliable patent system. And the reliability of our patent system is really premised on those foundational rights and remedies that are really the focus of this conversation today. The ability of a reliable system of exclusive rights to, again, incentivize the R&D investments, to ensure an opportunity to receive a return on those investments, and to create confidence in the market when you share those investments or those technological breakthroughs broadly. So just to kind of put some practical dimensions to what we're talking about today, I think there's a lot of conversation in the country today, across the world, around the importance of technological leadership. We have enjoyed as a nation that position of technological leadership in large part because of the strength of our system of intellectual property rights, backed by a strong rule of law, backed by strong rights and remedies. But when we start to erode the foundation of that system, we really put into jeopardy whether we can maintain leadership in these critical spaces. So I'll stop there.
Thank you all for your insights. It's tremendously interesting to hear from each of you and how things differ across industries and sectors. The focus of our panel is on the importance of exclusive rights. And exclusive rights, for example, provide a patent owner the ability to exclude others from using their ideas or technologies. And as you've alluded to, that is far too simple. They are valuable in other ways and for other reasons as well. If we may first hear from John, would you please briefly explain why and how exclusive rights are valuable in your industry in particular?
Well, I think I mentioned earlier that Nokia as a company has about 4,000 standard essential patents. And I'm going to focus my remarks here just on that particular niche. For those of you who aren't aware, standards essential patents are those that are declared as essential to a particular standard that your company might be jointly developing with lots of other companies. And usually when you declare your patent as essential to a particular standard, the quid pro quo for getting the technology adopted into the standard is that you agree that you're going to license that standard to anyone who needs to make products using it on a fair, reasonable, and non-discriminatory basis. So you're sort of basically capping the amount of royalty you can obtain in return for getting that into the standard and hopefully getting a large dissemination of your technology and lots of users out there. But the problem then becomes that unlike proprietary technology that you keep to yourself, the roadmap is out there for anyone to use your technology and to go ahead and make products based on it. So you're not going to be able to prevent someone from using your technology because you've dedicated it to the standard. But you need to be compensated for that, right? So you want to go out there and you want to negotiate with those parties that are developing products and using the standards and using the technology that you contributed. And so Nokia, we have an entire business, a licensing operation that goes and negotiates with product manufacturers who are developing standard essential products that use the standards and the technology. And by and large, we're successfully able to negotiate with these companies and reach amicable resolutions outside of court. I think over the past 5 years, we have reached agreements close to almost 200 different license agreements with users of our technology, and we've only had to resort to litigation on I think a low single digits number that I could count on one hand. But sometimes we do have to resort to litigation. The problem with that is that we have a large, enormous portfolio of patents, and that portfolio spans over 20,000 assets in multiple different jurisdictions, over 4,000 families worth. And it's not practical to go and assert each of those patents in each of those jurisdictions. So sometimes when we can't reach agreement amicably with a potential licensee, it's an irrational, economically defensible decision on their part to simply go and infringe and wait for us to come and sue them, because they know that we can only assert a certain number of patents at a time in a certain number of jurisdictions, and it's going to cost us a tremendous amount of money and personnel resources to try to enforce those rights. And therefore, it makes more sense for them to hold out and wait for us to try to obtain that compensation by way of litigation. Some economists have termed this economic infringement, which is a sensible decision on the part of the infringer, because our royalties are capped at a fair, reasonable, and non-discriminatory rate. So they know that if they just wait and make us sue them, they're likely going to only pay what they would have had to pay anyway had they come to a license agreement with us, and that they'll be able to do it years later down the line. Now, when we have a huge, enormous portfolio of patents, we need to somehow be able to bring that accused infringer, that potential licensee, to the bargaining table to negotiate in good faith with us. And the one method that we have to do that really is the power of the injunction and injunctive relief. Even though we can only get compensation, a small amount of compensation for a particular number of patents that we might be able to assert, we can obtain injunctive relief that will prevent that manufacturer from putting its products on the market for a time, so long as we have negotiated in good faith from our end and given them what are considered to be fair, reasonable, and non-discriminatory license offers. So getting back to the question that Kristina raised, here it's the power of the exclusionary right that allows us to have a better negotiation, that allows us to bring the accused infringer, the potential licensee, to the table when they otherwise might just sit back and not pay us or wait for us to individually sue them in jurisdiction after jurisdiction with patent after patent and not give us a fair return or enable us to recoup the investment that we made in our research and development to obtain the patents in the first place.
I welcome any of the rest of you to comment on John's thoughts or bring your own as well.
If I could go. I think John mentioned in his opening remarks how Nokia relies on ongoing licensing revenue to help fund research and development. And you see something similar in the publishing industry, right? So publishers aren't in the business of putting out a single book. They're in the business of putting out books every year, year after year. And many publishers, they'll divide their titles into frontlist titles, the new releases, and backlist titles. And depending on the publisher, that can mean anything that's 18 months to 2 years old. And obviously they want, every one of their frontlist titles to be a big hit. As I mentioned in my opening remarks, no one can really predict what's going to be a hit or not. But what they can rely on is that backlist, because over time they build up this backlist, and it provides a very steady and stable form of revenue. In some cases, for some publishers, backlist revenue could be as much as half of their annual revenue. So that's revenue that's predictable, relatively speaking, not always. I mean, publishers will pay close attention to the titles on their backlist because things may happen that make them more in demand. Netflix could have a series based on a book that's 10 years old, and everyone wants to go out and buy the book, or they put out a new edition, or maybe it takes a few books for an author to kind of break out, and now all of a sudden there's demand for all the books that the author previously published. Or maybe a book is picked up and adopted in schools as part of curriculum or adopted in college classes, and so that builds demand for these older books. But generally speaking, I mean, this is predictable, reliable, stable revenue that both pays the operating costs of the publisher, but also acts as a source of venture capital for new titles. Right? This is where they get the money to pay for authors to put out books where they may not know, is this going to be a hit or not? It gives them the opportunity to take more risks. And so any time you erode the exclusive rights, you're eroding that capital stream. You're eroding the source of investment for new titles, for new authors, for new books. And so that's really why, for publishers, exclusive rights are really central to their ability to operate. I mean, you wouldn't have a publishing industry the way we have it today without those exclusive rights.
And if I could just add as well, I think because it's worth repeating, the role of the exclusive right beyond, the R&D investment dynamic that we've discussed is to avoid litigation. Whether you're a large company like a Qualcomm or a Nokia, but particularly if you're a small company, the last thing you want as the inventor or the creator of intellectual property is to have to rely on a court system to ensure that return on investment. For companies like Qualcomm, again, we are also licensing at a portfolio level. Our portfolio is probably, I can't tell you the exact number, it's around 150,000 issued and pending patents, a global portfolio. The notion that that a judge is going to be able to determine a valuation of that portfolio in a way that's really reflective of the true value of that portfolio, the investment of your R&D, is really, I think a misunderstanding of how these innovation markets work. And that's kind of where we are today in the United States, because there is no meaningful access to injunctive relief, at least in the patent space. We have reached a point where because the injunction is no longer serving the intended purpose of incentivizing users of technology to come to the table and negotiate on a bilateral basis, increasingly we're using judges as kind of a proxy for determining that value. And of course, in any litigation, you're talking about litigating a handful of patents relative to the hundreds of thousands of patents that may be reflective of the true value of that portfolio. If you're a startup or a small company, again, if litigation is displacing the market as the determiner of value, you're greatly disincentivizing R&D investments and private capital investments in the first place. Because for any small company, litigation is like it's a long, torturous, expensive process where the better resourced company is always going to be able to tie you up in knots of one form or another before there's any sort of meaningful resolution. So I think it's just important to emphasize that we do not want a system of innovation where courts and judges become the sort of arbiter of value or the only recourse that an intellectual property owner has to achieve any kind of return on that investment. That is a fundamental breakdown in how these innovation markets are intended to work. And what we're seeing globally is that because the United States no longer has a reliable system of exclusive rights, at least in the property space, increasingly companies like Qualcomm are having to rely on foreign court systems where there is access to injunctive relief. And again, think about what that means in terms of the leadership that the United States has historically held, not just in terms of our innovation economy, but the legal foundation of that innovation economy. And I think it really is a troubling state of play when our system of laws is no longer the solid foundation that it needs to be to sustain that innovation R&D equation. So I'll stop there.
Well, I can only associate myself with what's been said. Perhaps I can offer, like the one thing I might have to offer at this point would be illustrations of counterfactuals, right? Because that's sometimes helpful if you ask about, what do exclusive rights do for any given industry? How does it work? What's the benefit? Sometimes you can look at situations where what happens without exclusive rights, or maybe more interestingly, what happens when there are exclusive rights and then those rights go away, and then what happens? Right? Is it going to be wonderful? Is there going to be more innovation when those rights go away, when patents expire? Is there going to be less innovation? Is there going to be more of the product? Is there going to be less of the product? Is it going to become cheaper or more expensive or whatever, right? So, and we have lots of examples of those, I think in many industries, and I know the ones that happen in our industry. So, one example, right? Pretty common. It is pretty common. After about a typical period of around 13 years, right? So when a new drug that was never before used and that uses a new molecule that had never before been used, when such a new innovative drug first goes to market, it stays on the market without generic drug competition on average for about 13 years. Right? And this is partly due to patent protection, partly to other factors. I don't even care. But the empirical number is for drugs to be in the market without generic competition. And that's not brand-on-brand competition. That often exists in parallel, but without generic competition for about 13 years. At some point in the life cycle of a typical innovative drug, especially if it's a small molecule drug. There comes a time when generic entrants or would-be generic entrants who want to sell cheaper copies of the identical drug, they all show up at the Food and Drug Administration with their applications to also be approved to market a generic equivalent. It is common for 5, 6, 8, or 10 of them to show up on the same day at the Food and Drug Administration and to together go through the review process, the approval process at the FDA. And eventually, it's also pretty common for them all to launch products very close in time. And then what happens? So whatever, 6, 7, 8 generics, are they all going to launch? Are 10 generics all going to launch their product? Because they all showed up at the FDA with their applications. What? Now they're all approved. What happens? Well, only about half of them actually even launch a product. Right? And of the ones that do launch a product, maybe half of them stay in the market for the next 5 to 10 years. Right? Most of them eventually leave the market, and we're left with a generic market that's supplied by maybe 2, maybe 3 suppliers, sometimes 1, sometimes none. That's how we get drug shortages in this country, which is a really weird thing to think about, right? A country like America or rich countries in Europe that don't have access to medicines. Well, it's not the patent system to blame, it's something else, but there are hundreds of drugs on the shortages list in Europe and in the US as well. You all may know somebody who has difficulties getting their drug, which used to be available for pennies last year. Now it's just not available at any price in the pharmacy. Weird, right? These things happen after patents go away, after dozens of people say we want to enter the market, but at the end of the day, only very few people actually serve that market, which is no longer protected by exclusive rights. It may be wonderful for consumers in the sense that those who do have access will pay much less. Often, at least in our space, that's probably true. Right? Or at least the payers who pay for these drugs, the insurance companies pay much less for them. But on other levels, it's not actually a nirvana that unfolds. Another more recent example, during the COVID pandemic, right? The first purpose-developed antiviral drugs, so I'm not talking about the vaccines, but the purpose-developed antiviral drugs to treat the symptoms of COVID and prevent its severity from progressing. These products were, even before they received emergency use listing by the Food and Drug Administration, these products were, I'm looking, some of the companies may actually be in the room, were widely licensed to generic drug manufacturers all around the world through various mechanisms, including one well-known mechanism called the Medicines Patent Pool. Right? So the intellectual property was made available under the exigencies of the pandemic. So these products, there were 2 drugs that were made available for licensing like this. They both received a large number of license applications, and they were licensed, in one case, to over 30 generic manufacturers around the world to also make COVID antivirals. Right? And you would think, wow, COVID, right? We're going to now finally, the market is going to be flooded by these products. They're going to become available to everybody. Out of 31 licensees, so took a license and manufacturers, maybe 2 or 3 actually launched a generic product, and we're talking COVID drugs, right? The others never even went to market, and people were wondering, what happened? What's going on? These products are being made available to every manufacturer who basically wants to make them, and only 2 or 3 of them actually started making them. It's economics, stupid. It's the economy at the end of the day. We could have predicted at the time that 30 licensees are too many, right? They're going to fall over each other's feet. It's like saying, how do we excavate a big pit? Right? Will we have 5 guys with shovels or 5,000? Right? At some point, it becomes silly. And indeed, right, all these companies that came and took licenses very quickly figured out, I don't want to be the 28th generic company that also goes to market with yet another copy and compete with all the others to sell my products for pennies. It makes no commercial sense whatsoever. Where does that leave us? I don't know, but I really do believe it sheds some light on how exclusive rights operate. Right? And while we so often hear that it is very, very important for any number of reasons to soften up exclusive rights and make products more widely available, let 1,000 flowers bloom, right? Let's have fewer patent rights. That in reality, whenever it's being tried, it doesn't actually work, and it never meets expectations. It only leads to more discontent and more policy proposals to do yet more. Finally, one thing that Laurie said I think really needs to be emphasized as much as possible. I've been ranting on about normal, very simple market mechanisms that are at play that everybody could understand and predict. But Laurie made the point that there are other economies who don't rely on these market mechanisms that we take for gospel and that always drive our commercial thinking, right? There are other systems that are top-down, that subsidize research, that direct research in the national interest, whose corporations are very compliant in following government directions, and are basically following a completely different model of research, both research direction and research funding. Using such a model in the United States, I think, would be simply impossible, right? Because not only is it less efficient, I believe, in the long run, it's also because our government doesn't have the money. If you look at policy proposals that systematically seek to soften intellectual property rights, you will find when you query these proposals and you look for their context, well, they're either being driven by incumbent commercial interests who just want to win lawsuits and get cheap technology for free. That's one reason why these policy proposals appear, right? But other reasons why it's often being argued to weaken intellectual property, when these policy proposals are being given, they're also often paired with calls for more government involvement, right? Even like scholars and social science scholars and economic scholars, patent hostile ones in this country, understand that if we weaken intellectual property rights, we also must change many other aspects of our economic model. And one of them will be a need for much more government funding, much more government control, and much more government direction. That's something that may make sense in China. I'm not a China specialist, but it does not make sense in the United States because our government simply doesn't have enough money, even if it wanted to direct research in the way the Chinese government does. Right? In the United States, the only way this will work is the way it has worked, and that is that federal funding for research, right, which we're generously spending in the United States. We really do, right? And it really is worth its own discussion. But that federal funding and research in the United States is supplemented by a factor of 10, 20, 100 to 1 by private dollars that are recruited into the market, right, on the strength of smart ideas, to which the public, of course, also contributes. But the US government, I swear, right, does not have nearly enough money for transforming the innovation model in the ways that patent critic economic proponents often say it should be transformed. So I think the counterfactual of China and the model that will eventually prevail, I think it's going to be fascinating to watch. I hope to not be around to see the outcome, because if we get this wrong in the United States, by the time we've figured out that maybe we had the wrong idea here, it will be too late to remedy. Right? We shouldn't play around with this. This is not something for experimentation.
Well, and by the way, and then I'll stop, there's actually quite a bit of economic literature that kind of looks historically at the effectiveness of the government as a arbiter of innovation winners and losers vis-a-vis the market. And the government hasn't done a great job historically. So I think, what Hans is alluding to is there's not only the sort of kind of practical economic impediments to that form of industrial policy in this country, but historically, industrial policy has been a poor substitute for the market in really spurring highly dynamic, successful, innovative activity.
Yeah. It doesn't work in democracies, in other words, right? Imagine a member of Congress saying, let's spend let's say the private sector spends, and in the biomedical space, approximately $140 billion per year, right, in R&D, product research and development in the biopharmaceutical space. So 140 billion, that's a pretty big chunk. Imagine a member of Congress saying, let's spend, in addition to the 40 billion we give to the NIH every year, let's spend another $140 billion, right, to drive more innovation that would otherwise be paid by a greedy and dysfunctional private market. Let the government do it. Well, they're going to need another $140 billion. And imagine being a member of Congress going around saying, let's spend that kind of money on a venture that's going to fail 90% of the time. Well, that is just not something that's going to work in a democracy. Lawmakers will not go there. If you remember Solyndra in California, right? Public investment in a private corporation, and they go broke, we're still hearing it. Right? So again, that may work in China. I think it's incompatible with democratic free market systems.
There's obviously a great deal to learn from the four of you and a great deal more to cover. But we're down to our final 5 minutes, so I welcome any questions or comments that may come. There are microphones on either side. If you would line up and announce yourself so that we can hear your question, I would appreciate that. Please, sir.
We can, but
well
the
enough. I
microphone-
don't
yeah.
think your mic is live.
Hello.
Yes.
Great. Excellent remarks. Thank you. I have a question. I think it's principally going to be for Laurie and John, related to patents and standard essential patents in particular. So clearly, you both related the fact that post-eBay, it's very difficult to get an injunction, and so the best you can do is get a FRAND royalty eventually, which gives an incentive to the disputing licensee, prospective licensee, to hold out. There is another mechanism by which you can get something like an injunction in the United States. So most of the equipment, like phones and such like, are manufactured abroad. So from the International Trade Commission, it is theoretically possible, at any rate, to get an exclusion order. So can you explain how effective or that mechanism is as an alternative to getting a standard injunction in the district courts in the United States these days?
Sure. The answer is that it is reasonably effective. It's probably the best chance that a patent holder is going to get to obtain an injunction in the United States. It has some drawbacks in that if you're attempting to enforce a standard essential patent, we have only one example where that was done. It was several years ago. Samsung did obtain an exclusion order against Apple with respect to some of their products, and then the way the review process works for the ITC, there is eventually a presidential review process in which the president or the president's delegated representative, which in this case is the United States Trade Representative, can veto an exclusion order if it so chooses. And in that instance, the government actually did veto the exclusion order on, I believe it was public interest grounds. So you can't guarantee that you're going to get the result, even when you get the result that you think you've gotten. So it is a helpful venue, but even the International Trade Commission is currently under some attack by patent scholars who are arguing that it no longer serves the purpose it was initially intended to serve, which was to protect U.S. industry, because they're claiming that many of the users are non-practicing entities who aren't actually manufacturing products anyway. But that's discounting the fact that a lot of those non-practicing entities have licensed their technology to others who are indeed manufacturing products in the United States and developing industries here. But along those lines, I'll just mention that even as recently as July, the House Judiciary Subcommittee on Courts, Intellectual Property, and the Internet held a hearing on IP litigation and the U.S. International Trade Commission, in which they were ostensibly evaluating the role of the ITC, and 3 of the 4 speakers there, including an academic by the name of George Contreras, who has written papers on this, spoke out against the ITC as a forum and criticized the ability of patent holders to use it to obtain injunctions that they think they wouldn't otherwise be able to get in district courts.
So the idea is to more or less use the district court framework and transpose it to the ITC. That's what a lot of the critics at the end of the day want to do, in addition to changing the definition of domestic industry.
Yeah, because most of the critics recognize that in the district courts now, you're governed by the eBay standard from the Supreme Court 20 years ago, which said that injunctions, which heretofore had been automatically given for a patent infringement, would only be given if the patent holder were able to meet a certain set of criteria, which have effectively proven quite difficult to meet, because one of them is that you have to show that there would be irreparable harm, which is often difficult for a patent holder to show practically.
Well, and just to add a few comments, I mean, this debate around the ITC has been underway for at least 15 years. And, you know, again, just a shout out to all the amazing scholars who actually, you know, do the hard work of looking at the real data behind institutions like the ITC. But this notion that somehow the ITC is fraught with abusive, you know, so-called troll litigation is completely devoid of any sort of factual basis. If you look at the actual numbers of cases that are brought at the ITC, the actual numbers of exclusion orders that are granted, the prevalence of so-called NPE litigation, it's very, very low. And actually the ITC for a long time did a great job of tracking data in a way that really, you know, debunked very resoundingly that kind of false narrative. I think the notion of importing the eBay standard into the ITC makes no sense. I mean, again, the ITC, the exclusion order is a trade remedy. It's distinct, you know, in its kind of legal basis from the kinds of injunctions we associate with the patent system, you know, more broadly. But, you know, the premise of the eBay standard, which I think we could spend the next, you know, several hours debating, is that somehow monetary damages are an appropriate alternative to injunctive relief. The ITC has no authority to issue monetary remedies. So again, it's this entire debate around the ITC is just kind of fraught with legal, logical, factual errors. And I think if you look at the role of the ITC as creating an efficient in rem, meaning the remedy attaches to the infringing product as opposed to a party, it is for many intellectual property owners, you know, the most impactful, efficient means of ensuring that the U.S. market is not flooded with infringing products of one form or another. So I would just encourage folks, you know, who are looking at this issue to think about the facts and think about the consequences of eviscerating yet another institution that's become a real barrier to, you know, large-scale infringement of U.S. intellectual property owners.
So it doesn't sound like the ITC has done one whole hell of a lot for SEP holders so far.
Well, I mean, I guess the proof is in the pudding, in the sense that I would say that, for example, my company currently has a multi-jurisdictional around the world dispute ongoing with Amazon. And we have enforced our patents, or chosen to enforce our patents, at the ITC. And so I guess that's you know, some indication of the value that we continue to see on the forum for possibly helping us to obtain our right.
Are they SEPs or just patents?
They are standard essential patents, but on the video compression side.
And with that, we are out of time. Thank you for your attention, and many thanks to the panel.